Et selon Cécile, c'est Josh
All
qui va le
rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Court officer, please call the case.
Thank you, Mr. President. The situation in the Democratic Republic of the Congo in the case of the prosecutor versus Bosco Ntaganda. Case reference ICC 0104-0206. For the record, we are in open session.
Thank you, court officer. I'm Judge Chang Ho Chung, and today I will be presiding this hearing. To my right is Judge Robert Fremer, and to my left is Judge Olga Herrera Carbucha. I welcome everyone to this hearing, which is being held with some additional security measures due to the exceptional circumstances. For the same reason, the Defense Counsel for Mr. Ntaganda has informed the Chamber that he will follow these proceedings remotely, as you can see in the screen. I would like to thank everyone for cooperating in ensuring the efficient conduct of proceedings in this case. Now I'd like to ask the legal representatives of the victims, the defense team for Mr. Ntaganda, the representatives of the registry, Office of the Prosecutor, and Trust Fund for Victims to introduce themselves and their teams for the record. The legal representative victims first.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Good morning, Mr. President. Good morning, Your Honors. The victims of the attacks are represented by myself, Dmitry Supron, counsel at the Office of Public Counsel for Victims. Thank you.
Good morning, Mr. President, Your Honors. I am Melissa Beaulieu-Lucie, legal assistant for Mr. Bosco Ntaganda. In the courtroom with me, there is Maître Laurence Hortas-Laberge, and remotely there is Maître Bourgon, that is present remotely, and also Didas Nirinkwaya, pro bono legal assistant, assisting remotely. Thank you.
Any from no registry, then Office of the Prosecutor, please.
Good morning, Mr. President. Good morning, Your Honors. Appearing for the prosecution today are Ms. Merichel Rege and myself, Nicole Sampson.
Good morning, Mr. President, Your Honors. For the Trust Fund for Victims, representation is by Ms. Franziska Ackermans, legal advisor, and myself, Peter de Baan.
Thank you. Members of the legal staff of Trial Chamber 6 are also present at this hearing. We gathered today for the Chamber to pronounce its order on reparations to victims under Article 75 of the Rome Statute in the case of the prosecutor versus Bosco Ntaganda. As provided for by Rule 144, paragraph 1 of the rules, the Chamber delivers a public summary of its main findings and conclusions in the presence of the accused, the legal representatives of victims, and the prosecutor. The Chamber underscores that only the written reparations order, which was filed this morning and will be notified shortly after this hearing, is authoritative. Timing for the issuance of this order and the type of reparations granted. I shall begin today by noting that in order to contribute towards more expeditious reparations proceedings, and considering that the mandate of two of the Chamber's judges comes to an end on 10 March 2021, including that of Judge Fremer, who presided over the trial, the Chamber has decided to issue this reparations order prior to the issuance of the appeals judgment on the conviction and sentence. In that respect, the Chamber recalls the victim's right to prompt reparations, that the crimes for which Mr. Ntaganda was convicted took place almost 2 decades ago, and most victims have received little to no assistance so far, and that due to their particular vulnerability, some victims may require urgent assistance. As to the type of reparations awarded, the Chamber notes that after detailed consideration of the submissions of parties and other participants in the proceedings, report from the registry and appointed expert, the Trust Fund for Victims, relevant case file records, and the applicable legal framework, the Chamber has concluded that awarding collective reparations with individualized component is the most appropriate course of action in the present proceedings. The Chamber reached this conclusion in light of the scope of the case, the potentially large number of unidentified eligible victims, the extent of the harm the victims suffered, and the scope, types, and modalities of reparations the Chamber considers appropriate to address such harm in the circumstances of the case. The Chamber stresses that in reaching this decision, it particularly took into account the victim's wish not to be granted any form of memorialization or other types of symbolic reparations unless they serve practical purposes, and their wish to receive awards aiming at supporting sustainable and long-term livelihood and well-being rather than simply addressing their needs on a short-term basis. Scope of the case. Moving now to the background and scope of the case, the Chamber recalls that on 8 July 2019, Mr. Bosco Ntaganda, the former Deputy Chief of Staff of the UPC FPLC, was found guilty of 5 counts of crimes against humanity and 13 counts of war crimes, namely murder and attempted murder, intentionally directing attacks against civilians, rape, sexual slavery, persecution, pillaging, forcible transfer, deportation, and ordering the displacement of the civilian population, conscripting and enlisting children under the age of 15 years into an armed group and using them to participate actively in hostilities, intentionally directing attacks against the protected objects and destroying the adversary's property. The crimes were committed in the context of at least one non-international armed conflict between the UPC FPLC and opposing organized armed groups in the Ituri district of the DRC from on or about 6 August 2002 to on or about 31 December 2003, and a widespread and systematic attack against the civilian population conducted by UPC FPLC between August 2002 and May 2003. Within that context, the UPC FPLC committed a series of crimes during a first operation in the Banyali-Kilo collectivity in November-December 2002, and a second operation in the Wallendu-Jachi collectivity in February-March 2003. The UPC FPLC also conscripted and enlisted children under the age of 15 years between on or about 6 August 2002 and 31 December 2003, and used them to participate actively in the hostilities between on or about 6 August 2002 and on or about 30 May 2003. Principles on reparations. Pursuant to Article 75, Paragraph 1 of the statute, the court shall establish principles relating to reparations which are to be distinguished from the order for reparations. The Chamber has adopted the 13 principles identified by the Appeals Chamber in the Lubanga case as adapted in the Katanga and Almaty cases, as they are of general application. The Chamber has adapted and expanded such principles as detailed in the order, and has also identified 6 additional new principles as necessary in light of the specific circumstances of the case. The new principles identified by the Chamber are principle of do no harm. This refers to the need to take all steps necessary to ensure that access to justice and reparations by victims and affected communities does not lead to further or secondary victimization, does not create or exacerbate security concerns or tensions among communities, and that victims are not endangered or stigmatized as a result. Particular attention should be paid to victims belonging to more vulnerable groups. Principle of gender inclusive and sensitive approach to reparations. This approach should guide every step of the reparation process. It requires the court to give due consideration and address the specific needs of individuals based on their sex and their real or perceived gender expression or identity without discrimination on that basis. This approach should integrate intersectionality as a core component and take into account the existence of previous gender and power imbalances, as well as the differentiated impact of harm for victims. Principle related to sexual and gender-based violence. Sexual and gender-based violence refers to crimes committed against persons because of their sex or gender expression or identity. The principle recognizes the court's obligation to adopt all necessary measures to ensure that the victims of these crimes come forward and benefit from reparations, and it addresses the potential obstacles, including stigma and ostracism, without reinforcing pre-existing discriminatory patterns. Reparations should recognize especially the grave nature and consequences of these crimes and should reflect and address the multifaceted harm suffered by the victims. Principle of prioritization. All victims are to be treated fairly and equally. However, priority may need to be given to certain victims who are in a particularly vulnerable situation or require urgent assistance. The court may adopt measures in order to guarantee equal, effective, and safe access to reparations for particularly vulnerable victims. The principle of transformative reparations. Reparations should strive to be transformative in their design, implementation, and impact. They should have a rectification effect, confronting social exclusion by prioritizing a participatory process over outcomes and by challenging unequal power relations. Principle of no overcompensation. Reparations may neither enrich nor impoverish the victim, but adequately repair the harm caused to the extent possible. Granting multiple modalities of reparations for the same harm suffered by the victims shall not be regarded as an overcompensation. Orders for reparations against Mr. Bosco Ntaganda, elements of a reparations order. As determined by the appeals chamber, a reparations order must contain, at a minimum, 5 essential elements. The chamber will hereafter detail its findings with reference to those elements. Eligible victims. The present order is for collective reparations against Mr. Ntaganda to be made through the Trust Fund for Victims pursuant to Rules 97, Paragraph 1 and 98, Paragraph 3 of the rules. In light of the type of reparations awarded, the Chamber establishes the eligibility criteria for reparations, including the characteristics of the categories of eligible victims, in order to enable their identification by the Trust Fund for Victims. The Chamber stresses that eligibility for reparations is to be determined by reference to the territorial, temporal, and subject matter scope of the crimes for which Mr. Ntaganda was convicted. Direct victims. Natural and legal persons are eligible for reparations as direct victims if they can demonstrate at relevant standard of proof that they suffered a harm as a result of at least one of the following crimes. Victims of the attacks. Count 1 and 2. Victims of murder and attempted murder as a crime against humanity and as a war crime in Mongboallu, Unjebi, Sayo, and Kilo in the context of the first operation, and in Kobu, Sangi, and Bambu in the context of the second operation. Specifically, in the context of the first operation, Abe Buanalonga in Mongboallu, a woman in front of the health center in Sayo, people in Mongboallu and Sayo during Latisage operations, including a Lendu woman and the persons killed at the apartment camp, 2 Lendu persons in Njebi and Lendu persons, a Ngiti man, a pregnant Lendu woman, and a Nyali man in Kilo. In the context of the second operation, at least 2 fleeing children in Kovu, and the people during the Latisage operation that followed, 9 hospital patients in Bambu, a woman who was raped, and P0018 sister-in-law in the bushes surrounding Sangi, at least 49 persons in a banana field near the Paradiso building in Kobu, and some men who were raped by UPC FPLC soldiers in Kobu. And in the context of the first and second operation, the attempted murder of P0018, P0019, P0022, P0108, and a patient of Bamboo Hospital. Count 3. Victims of intentionally directing attacks against civilians as a war crime in Mongboallu and Sayo in the context of the first operation, and in Bambu, Jichu, and Bulli in the context of the second operation. Count 4 and 5. Victims of rape as a crime against humanity and as a war crime in Mongboallu and Kilo in the context of the first operation, and in Kobu, Sangi, and Buli in the context of the second operation. Specifically, in the context of the first operation, women and girls during and in the aftermath of the UPC FPLC assault on Mongboalu, including a number of women in the apartment camp and girls in Kilo. And in the context of the second operation, detained women and men in Kovu, women in Sangi, and P0113 in Buli. Count 7 and 8, P0113 and an 11-year-old girl as victims of sexual slavery as a crime against humanity and as a war crime in Kobu and Buli in the context of the second operation. Count 10, victims of persecution as a crime against humanity in Mongboalu, Unjebi, Sayo, and Kilo in the context of the first operation, and in Nyangalai, Lipli, Chili, Kovu, Bambu, Sangi, Gola, Jitchu, and Buli in the context of the second operation. Count 11, victims of pillage as a war crime in Mongboalu and Sayo in the context of the first operation, and in Kobu, Lipli, Bambu, and Jitchu in the context of the second operation. Count 12 and 13, victims of forcible transfer and deportation as a crime against humanity, and ordering the displacement of the civilian population as a war crime in Mongboalu in the context of the first operation, and in Lipli, Chili, Kob, and Bambu in the context of the second operation. Count 17, victims of intentionally directing attacks against protected objects as a war crime, namely against the health center in Sayo in the context of the first operation. Count 18, victims of destroying the adversary's property as a war crime in Mongboalu and Sayo in the context of the first operation, and Lipli, Chili, Kobu, Jitchu, Buli, and Sangi in the context of the second operation. Child soldiers victims, count 14, 15, and 16. Victims of conscription and enlistment of children under the age of 15 years into an armed group between on or about 6 August 2002 and 31 December 2003, and their use to participate actively in hostilities between on or about 6 August 2002 and on or about 30 May 2003, with respect to the participation of children under the age of 15 in the first operation and in the UPC FPLC assault on Bunia in May 2003. The use of children under the age of 15 as bodyguards for UPC FPLC soldiers and commanders, and the use of children under the age of 15 to gather information about the opposing forces and MONUC personnel as war crimes. Count 9 and 6 and 9. Victims of rape and sexual slavery of child soldiers as war crimes against children under the age of 15 years incorporated into the UPC FPLC between on or about 6 August 2002 and 31 December 2003 in Italy. Specifically, the rape of Ntaganda, an approximately 9-year-old girl at Camp Lingo, and the rape and sexual slavery of P0883, a girl under 15 years of age at Camp Bulle, and Mabe, and a girl under the age of 15 years assigned to Floribert Kisembo. However, these findings are not representative of the numbers of female UPC FPLC victims who were subject to rape and sexual violence, which was a common practice in the UPC, FPLC during this time period. Children born out of rape and sexual slavery. The Chamber recalls that a number of victims of rape and sexual slavery, including girls under the age of 15, became pregnant and children were born as a result. To qualify as a direct victim, a causal link must exist between the harm suffered and the crimes of which an accused person is found guilty. For direct victims, it must be established that because of the person's relationship with the direct victim, the loss, injury, or damage suffered by the latter gives rise to their harm. In light of the circumstances of the case, the Chamber considers that the children born out of rape and sexual slavery may qualify as direct victims, as the harm they suffer is a direct result of the commission of the crimes of rape and sexual slavery. In contrast, other children of women and girls who are victims of rape or sexual slavery may be considered indirect victims of the crimes for which Mr. Ntaganda was convicted, as they may have suffered harm as a consequence of the harm suffered by the direct victims. The Chamber notes that recognizing children born out of rape and sexual slavery as direct rather than indirect victims is an acknowledgement of the particular harm they suffered and may constitute an adequate measure of satisfaction in addition to other forms of reparations they may be awarded to them. Indirect victims. As to indirect victims, the Chamber relies on the Appeals Chamber jurisprudence and recognizes as indirect victims all categories identified in the Lubanga case. The Chamber reiterates that the key consideration is the personal harm. Indirect victims must demonstrate at the relevant standard of proof to have suffered harm because of the commission of a crime against the direct victims. To define the harm caused to direct and indirect victims, the Chamber considered all relevant information before it, including the judgment, the sentencing judgment, evidence submitted during the trial and sentencing proceedings, observations by the parties and other participants in the proceedings, including the registry, the trust fund for victims, and the appointed expert. The Chamber has defined the harms suffered as a result of the crimes committed by Mr. Ntaganda as follows. A. Harms suffered by the direct victims of the attacks. Material harm, physical injury and trauma, including memory loss, neurological disturbances, and extensive physical scarring. Psychological trauma and the development of psychological disorders such as inter alia suicidal tendencies, depression, and dissociative behavior. Psychosocial trauma due to exclusion from and disintegration of families and communities. Loss of productivity capacity, reduced standard of living, and socio-economic opportunities. Interruption and loss of schooling and vocational training. Exposure to an environment of violence and fear. Loss of childhood. Loss of life plan. And damage to the health center in Sayo, and loss of adequate health care provision to the community that benefited from it. B. Harms suffered by direct victims of crimes against child soldiers. material harm, physical injury and trauma, psychological trauma, and the development of psychological disorders such as intralia, suicidal tendencies, depression, and dissociative behavior. Psychosocial trauma due to exclusion from and disintegration of families and communities. Interruption and loss of schooling and vocational training. Separation from families. Loss of childhood. Loss of life plan. Exposure to an environment of violence, fear, and threat. Difficulties socializing with their families and communities, including rejection and stigmatization. Difficulties in controlling aggressive impulses, and non-development of civilian life skills, resulting in the victim at a disadvantage, particularly as regards employment. C. Harm suffered by direct victims of rape and sexual slavery, including child soldiers and children born out of rape and sexual slavery. Physical, psychological, psychiatric, psychosocial, and economic consequences, including injuries, trauma, ostracism, stigma, and social rejection in immediate and longer term in the case of the direct victims of rape and sexual slavery, and the physical, psychological, psychosocial, and economic consequences, including rejection at multiple levels, discrimination, and marginalization in the case of children born out of rape and sexual slavery. D. Harm suffered by indirect victims. Material deprivation that accompanies the loss of the family members' contributions. Loss, injury, or damage suffered by a person intervening to attempt to prevent the direct victims from being further harmed as a result of the relevant crime. Psychological harm experienced as a result from the sudden loss of a family member, including behavioral disorders such as trauma, depression, suicidal tendencies, and feelings of hatred. Psychological harm and trauma as a result of what they witnessed during or after the attacks. Psychological, psychosocial, and material harm resulting from aggressive behavior by former child soldiers reunited with their families and communities, and transgenerational harm of children of direct victims. Due to the limitations that leading the summary of the reparations order imposes, the Chamber is not able to describe in more detail in this hearing the great suffering and the long-lasting consequences suffered by all victims of the crimes for which Mr. Ntaganda was convicted, as elaborated in the order. However, particularly on this day, the Chamber would like to recall some of the testimonies heard during the trial proceedings. These testimonies exemplify that the crimes of rape and sexual slavery resulted in fear of stigma and ostracism for the victims within their families and communities, as well as fear of abandonment by their partners if information about the crimes would become known. Testimonies of witnesses heard during the trial proceedings account for victims having difficulties to stay with everybody, and that the crime affected the victim's personal development and life plan. A victim also recounted that after her rape, she, and I quote, was torn inside and out, was seriously injured for a long time, explaining I quote again, the abuse instilled a lot of fear in me. I could no longer go to school and was traumatized in my heart for a very long time. An expert witness who interviewed victims of the case testified that typically women or indeed men who have been sexually violated will feel contaminated, dirty, and unclean because of the nature of the violation, the very private violation that they have experienced. She added that the victims she interviewed felt extreme anger, which affected their children. Types and modalities of reparations. As noted above, the Chamber has concluded that collective reparations with individualized components are the most appropriate type of reparations, as they may provide a more holistic approach to address the multiple harms suffered by the large number of victims eligible to receive reparations in this case. In addition, it aims to provide victims with a sustainable and long-term livelihood and well-being rather than simply addressing their daily needs on a short-term basis. It also ensures a more efficient, prompt, and practical approach. At the same time, the Chamber considers that this approach addresses the concerns the victims should receive equal reparations to avoid wars being a source of jealousy, animosity, or stigmatization among the affected communities and between inter-ethnic groups, especially given the unstable security situation on the ground. It will also ensure that reparations respond to the victims' harms and needs, as determined following the Trust Fund for Victims consultations with the victims at the implementation stage. The Chamber further notes that collective reparations with individualized component appear the most appropriate type of reparations to address the harm caused by rape and sexual slavery and that suffered by former child soldiers, particularly considering the potential reluctance of these victims to come forward if they were to be singled out for specific hours due to their rejection and stigmatization at the family and community levels. As to the modalities of reparations, the Chamber acknowledges that the multiple, diverse, and multifaceted nature of the harms suffered by the victims in this case makes it difficult to reinstate the victims to the situation they were in before the commission of the crimes. In order to address the various harms suffered by the victims in the best manner possible, a combination of different modalities of reparations available should be applied. The modalities of reparations may include measures of restitution, compensation, rehabilitation, and satisfaction, which may incorporate, when appropriate, a symbolic, preventative, or transformative value. The Trust Fund for Victims is therefore ordered to design a draft implementation plan on the basis of all the modalities of reparations identified in the order in consultation with the victims. The Chamber further notes that priority should be given to individuals who require immediate physical and psychological medical care, victims with disabilities and the elderly, victims of sexual or gender-based violence, victims who are homeless or experiencing financial hardship, as well as children born out of rape and sexual slavery and former child soldiers. order against the convicted person. Reparation orders are intrinsically linked to the individual whose criminal liability is established in the conviction and must be proportionate to the harm caused. As such, in light of the principle of accountability of the offender, this order for reparation is made against the convicted person. Scope of liability. The Chamber has followed the Appeals Chamber jurisprudence in previous cases, namely that the question of whether other individuals may also have contributed to the harm resulting from the crimes for which the person has been convicted is irrelevant to the convicted person's liability to repair that harm. In effect, it is not per se inappropriate to hold the person liable for the full amount necessary to repair the harm. The focus in all cases should be the extent of the harm caused and the cost to repair such harm, rather than the person's role and the mode of liability for which the person was convicted. Accordingly, the Chamber finds Mr. Ntaganda liable to repair the full extent of the harm caused to direct and indirect victims of all crimes for which he was convicted, regardless of the different mode of liability relied in the conviction and regardless of whether other may have also contributed to the harm. As to the shared liability of Mr. Ntaganda and his co-perpetrators in the crimes for which he was convicted, including Mr. Thomas Lubanga, the Chamber considers them all jointly liable in solidum to repair the full extent of the harm caused to the victims. The Chamber took into account the Trust Fund for Victims' submissions that the reparation programs in the Lubanga case constitute a collective award aimed at comprehensively repairing the harm suffered by all direct and indirect victims. Accordingly, and considering the principle of no overcompensation, the Chamber considers reasonable to adopt, for the purpose of reparations in this case, the reparation programs ordered by Trial Chamber 2 in the Lubanga case in relation to the overlapping victims and the harms of both cases. As a result, these programs should be understood to repair the overlapping victims' harm on behalf of both Mr. Lubanga and Mr. Ntaganda. It should be stressed, however, that this, under no circumstances, diminishes Mr. Ntaganda's liability to repair in full the harm caused to all victims of the crimes for which he was convicted. To the contrary, Mr. Lubanga and Mr. Ntaganda are jointly and severally liable to repair in full the harm suffered by the overlapping victims, and both remain liable to reimburse the funds that the Trust Fund for Victims may eventually use to complement the reparation awards for their shared victims. Regarding the additional harm suffered by the victims of rape and sexual slavery within the UPC FPLC and victims of recruitment beyond the temporal scope of the Lubanga case, for which Mr. Ntaganda bears sole liability, additional reparation measures should be implemented. As to the amount of Mr. Ntaganda's financial liability, the Chamber notes that it should focus on the cost to repair the harm, depending on the circumstances of the case and bearing in mind the overall purpose of reparations. Ultimately, the goal is to set an amount that is fair and properly reflect the right of the victims, bearing in mind the right of the convicted person. If the available information does not allow the chamber to set the amount with precision, it may, with caution, rely on estimates after making every effort to obtain calculations that are as accurate as possible. The chamber recalls the large scope of the case in terms of the crimes for which Mr. Ntaganda was convicted, and the potential large number of victims of such crimes eligible to receive reparations. The chamber notes that it has carefully considered the information and evidence provided by the registry, the trust fund for victims, and appointed expert, and the parties, all of whom have made substantial effort in helping the chamber reach accurate estimate as to the number of potentially eligible victims and the cost to repair the harms they have suffered. The chamber has concluded that thousands of victims may be eligible for reparations in the present case. However, the chamber is cognizant of the impossibility to predict in advance how many victims may ultimately come forward to benefit from collective reparations with individualized components during the implementation stage, particularly considering the widespread, systematic, and large-scale nature of the crimes for which Mr. Ntaganda was convicted. The chamber notes the estimation made by the appointed expert that at least 3,500 direct victims are potentially eligible for the reparations, but that the number of indirect victims could not be ascertained by them. The chamber also notes that a total of 2,121 victims were admitted for participation at the trial stage, including 1,837 victims of the attacks and 284 former child soldiers victims. The registry has also reported that in relation to the victims of the attacks, there may be at least 1,100 new potential applicants. As of December 2020, the trial chamber 2 has recognized 933 beneficiaries for reparations in the Lubanga case, all eligible for reparations in the Ntaganda case. However, the chamber notes that numbers detailed above do not reflect the totality of the potential beneficiaries of reparations in this case. It is clear that there is still a significant number of as yet unidentified potentially eligible victims for which no reliable figures are available. In effect, estimates vary greatly and range from at least approximately 1,100 to a minimum of 100,000 across all locations affected by Mr. Ntaganda's crimes. As to the cost to repair the harm, the chamber also has relied on conservative estimate made by the Trust Fund for Victims and the appointed expert. The chamber has equally considered the figures and assessment made by Trial Chamber 2 in the context of the Katanga and Lubanga cases in light of their similarities with the present case, as they relate to crimes committed in Ituri during the same time frame and as relevant to the types and modalities of reparations envisaged by the chamber. Nevertheless, the chamber notes that the victims of the case suffered different kind of harm, and in the context of collective reparations with individualized component, the cost to repair the harm for each individual may substantially differ from one to another. Having considered the appeal chamber jurisprudence, the chamber set an amount that it considers fair and appropriate in light of the circumstance of the case and bearing in mind the right of the convicted person based on all the information before it at this point in time on the basis of conservative estimate and weighing the need for accuracy of estimate against the goal of awarding reparations without delay. Taking all the above considerations into account, resolving uncertainties in favor of the convicted person, and taking a conservative approach, the chamber set the total reparations award for which Mr. Ntaganda is liable at $30 million. Implementation. In line with the court jurisprudence, the chamber seeks the assistance of the Trust Fund for Victims for it to design the award for reparations and determine the size, nature of the reparation award. Pursuant to Rule 98, Paragraph 3 of the Rules and Regulations 54 and 69 of the Regulations of the Trust Fund, the Chamber orders the Trust Fund for Victims to prepare a draft implementation plan which should clearly specify the objectives, outcomes, and activities identified as necessary in order to give effect to the order. Consultations with victims should take place for the purpose of designing and implementing reparations awards. The Trust Fund for Victims shall rely on the registry and the legal representatives of victims as appropriate in light of their mandate and expertise in order to ensure that the implementation process and consultations with victims comply with all principles on reparations as established in the order. The Chamber notes that no property and assets belonging to Mr. Bosco Ntaganda have been identified to date, and accordingly, the Chamber finds him indigent for the purpose of reparations. Noting Mr. Ntaganda's indigence, the Chamber encourages the Trust Fund for Victims to complement the reparation awards to the extent possible and engage in additional fundraising effort as necessary to complement the totality of the award. For the foregoing reasons, the Chamber hereby unanimously issue an order for reparations against Mr. Ntaganda. Orders collective reparations with individualized component to be awarded to direct and indirect victims of the crimes for which Mr. Ntaganda was convicted as specified in the order. Assesses Mr. Ntaganda's liability for these reparations at $30 million. Set the deadline for the Trust Fund for Victims to submit its general draft implementation plan by 8 September 2021, and the deadline for the Trust Fund for Victims to submit an urgent plan for the priority victims by 8 June 2021 at the latest. Finds Mr. Ntaganda indigent for the purpose of reparations at the time of the present order. request the presidency assistance with the support of registry to continue exploring whether Mr. Ntaganda possesses any undiscovered assets and to monitor Mr. Ntaganda's financial situation on an ongoing basis and vacate the deadline for the registry to report to the Chamber as set out in the first decision. This concludes the Chamber's summary and today's hearing. The Chamber wishes to thank again the interpreters, court reporters, and all other registry staff for facilitating this hearing. This hearing is adjourned.
All rise. Veuillez vous lever.